The Development Bank of Jamaica, Jamaica Venture Capital Program, and Caribbean Alternative Investment Association present a weekly webinar series, Building the Economy through Alternative Investments.
A special good morning to you from the offices of the Development Bank of Jamaica here in Kingston. I'm Audrey Richards, and I'm the project coordinator for the Jamaica Venture Capital Program. It's my pleasure to welcome you, our online audiences, on our various social media platforms. This is the fifth of our 7 webinar series, and it's been brought to you by the Jamaica Venture Capital Program in association with the Caribbean Alternative Investment Association. At this time, I'd like to acknowledge the Inter-American Development Bank for the support which they've given to the Venture Capital Program over the years, as well as the support given to the newly formed Caribbean Alternative Investment Association. Now, at this time, what we have recognized is that the COVID-19 has had an unprecedented impact on our various, whether our personal lives or our business lives. And as we seek to basically survive, recover, and grow post-COVID, we recognize that it's going to be business unusual. And that was the impetus behind us having this 7 webinar series. Now, today's webinar is a little different in that we're not looking at a particular product, but we're exploring the whole area of insolvency and what the new legislation can do for our businesses as they seek not just to survive, but to actually be rescued and recover after this COVID pandemic. We are really honored this morning to have with us a panel of our industry experts, and most of their resumes are on our website. At this time, I'd like to introduce our moderator, who is Mr. Dennis Chung, CEO of Supreme Ventures Services Limited. This time, over to you, Dennis.
Thank you, Audrey, for that introduction. Welcome, everyone. Today, we're going to be talking about something that not everyone wants to think about it, but is really very relevant in today's COVID environment. We're going to be talking about insolvency legislation. Can businesses impacted by COVID-19 be restructured and rescued? And this is very important given what's happening in the economies across the globe. We've seen that many companies and persons have already been impacted by it, and there are some people in the past who have been impacted and have come back and have been significant successes. We're talking about people like Larry King, Abraham Lincoln, even our own Donald Trump, Walt Disney, 50 Cent, Will Smith. Apple was on the verge of bankruptcy in 1997 and has become one of the biggest companies in the world today. General Motors, Chrysler, Marvel Entertainment, Texaco, and recently the coronavirus bankruptcies have included Gold's Gym, Neiman Marcus, J.C. Penney, and Hertz. So we want to explore that topic today because it's going to be crucial for us to not just think about what can happen, but also how we're going to restructure going forward. So today, my job as moderator is to control the experts we have with us today. My name is Dennis Chung, and we have a panel of experts that can guide you properly through it. We have first, I'm going to ask first Justice Ferdinand Smith, who is the supervisor of the Office of the Supervisor of Insolvency in Jamaica, to kick off, and he's going to give us an overview of what the legislative landscape is. And then he's going to be followed by Hillary Reid, who is a partner at Miles Fletcher and Gordon. And Hillary was the one who chaired the committee that saw the recent legislation in 2014 of the Insolvency Act being upgraded. It's like she had some premonition that we're going to need it in this year. And then Howard Mitchell, who used to be an attorney at law, he said, and, he's the immediate past president at PSOJ and actually had started a successful business listed on the stock exchange and sold it, and is going to start a few more, right, Howard?
Hopefully.
And then we have, and he's going to give us a perspective on the business environment and what can happen in terms of how the businesses use this insolvency legislation. And then we're going to have a perspective from overseas, from Mr. Barnaby Gowrie, who is a partner at Walker's Law in Cayman. So what we're going to do today is ask each presenter to just give us a 5-minute overview in that order, on their areas of expertise, and then we'll go into general discussion with the audience. So I'll open with you, Justice. If you could open the innings for us. Justice Smith. All right, it seems like we're having some difficulties with Justice Smith coming in. He was just on with us now. So I'm going to ask you, Hillary, what's your perspective? You are the one who has championed the current legislative environment that we have. What's your perspective on that? And as an attorney, can you give us your view?
Sure. So the insolvency legislation, at the time that it was introduced into the Jamaican landscape, the idea behind it was to find ways and opportunities to rescue debtors, either at the point when they're in trouble or when they see that trouble looming, coming ahead of them, and trying to see, is it possible to find ways to rescue them? There was an existing sort of opportunity under the Companies Act that existed, but it relied heavily on the courts and the courts' involvement, which therefore meant it was both time consuming and to some extent expensive. And the longer that a debtor is in bankruptcy and is therefore an undischarged bankrupt, the more impact it has on his ability to move forward, his impact on businesses, and therefore the stigma that goes with bankruptcy continues. So the legislation was very concerned with, are there opportunities for rescue? Can these persons be rehabilitated? Recognizing, in fact, that if you're going to give the debtors these kind of opportunities, then there's some amount of balance that needs to be there for creditors. And therefore, looking also at how do you give debtors, for example, additional financing that they may need in order to even take advantage of the opportunities to be rescued and rehabilitated. How do they get additional financing? And so the Act provides for scope for them to be able to say to their creditors, if you give me additional financing, we get the court's blessing in relation to that, you can get security over my assets that is even above any existing security that I've given. And this gives a very important opportunity to debtors to be able to seek additional financing during these difficult times when even creditors may be reluctant to try to help an ailing company. And the earlier that the debtors can get out of bankruptcy, the better and easier for them to then move on with their lives and with their businesses.
All right, thank you, Hillary. We don't have Justice back yet, so I'm going to ask Howard. I mean, Hillary mentioned two very important things: the stigma, which I mean you can speak to, and also the timing. So the quicker that people accept this, what do you see happening out there in terms of the business environment, and what is your view on what's going to happen and how people need to use this legislation?
Thank you, Dennis. I feel, first of all, that as business people, we have to be predictive and to be proactive. You have to know or have some idea of where you're going with your business and what is going on around you. It is clear, I think everybody understands that there was even before COVID-19, the world was not on strong and substantial economic legs. COVID-19 has made it much worse, and there's no question that there's a storm coming, perhaps even that there's a storm here. As a community of business people, we suffer from a culture of shame if someone fails at a business. If a business goes under, the the first issue that comes up is not looking at the fundamentals, but looking at the individuals and to try and ascribe blame to the individuals. That we have to rethink that, because I think the statistics will show you that the vast majority of small businesses, of micro businesses, of medium-sized businesses fail within the first 3 years of their inception. So failure is not, it's always an option, and it's not something we must hold ourselves responsible for, provided we have done what is necessary and tried to meet all the criteria. The other thing about it is, in terms of preparation, I have to stress this, because Jamaican culture especially, is we tend to ignore the fundamentals. We don't get our record keeping right. We are a verbal or an oral society. We don't write things down. In order to be able to save yourself in the eventuality of a working capital deficit or insolvency, you must have record keeping. You must know who owes you. You must know who you owe. You must know what you say to your inventories. And that is, by the way, how people can assist you, how people can help you get out of the issue. I welcome the insolvency legislation and the assistance that the Office of Justice Smith gives to people who are either perceive themselves running into trouble or who have run into trouble. And I think that what we as the business community need to do is to sensitize more people that this is available. So that, you know, I don't want to necessarily give Justice Smith too much work, but the fact is that that's why he's there. And what I would want to do, I want the associations in the business community and the banks, the finance houses, to encourage their members, their debtors, before we reach the stage of insolvency, before we reach to the point where we cannot return, is to go and avail themselves of the assistance of the Office of the Insolvency Regulator.
Okay, thank you. Justice, you hearing us now?
Yes, I'm so sorry. My computer just
Yes,
froze.
yeah, man, understand. So we've been talking, Justice, about the whole framework. Hillary gave us some background and how it gave us a perspective from the business point of view. In terms of the office, how prepared is the office to deal with the insolvency issues that may arise, and what has been your experience in terms of people using the legislation to restructure their businesses?
Okay, thank you very much. And again, let me apologize. If I might just give a little background, I think most of us would have known somewhat about the insolvency regime in Jamaica, but it was the modernization of the insolvency framework was over a decade in process. And in 2018, the Parliament passed the legislation. I'm mixing up the dates here, so sorry. In 2014, the legislation was enacted and came into force in January of 2015. And that act did away with the old bankruptcy law and replaced it, of course, as I said, with the Insolvency Act, and created a supervisor of insolvency and a government trustee. The importance of this act is that it is more debtor friendly, although it maintains and has done everything to protect the rights of creditors. But it has been said to be more, and it is indeed more debtor friendly and pro-debtor, seeking to rehabilitate debtors. And in so doing, it has set up what we call the proposal, which is a means of restructuring. So a company that is insolvent need not go into bankruptcy, and better yet, need not go to the court to resolve this problem. the Act provides for what we call a proposal. And indeed, even before insolvency, if a company sees that within the next 12 months, sometime during the next 12 months, it is bound to become insolvent on the happening of a particular thing, then it may file a proposal, even though not technically insolvent. It may file a proposal, and if that proposal succeeds, then it would have avoided insolvency altogether. Now, coming back to the proposal here, if the proposal is filed and accepted by the creditors, then of course, the debtor is in a position to reorganize and have a new lifespan, or a new lease of life, I should say, so to speak. But let me just mention, if you'll allow me, some of the new changes that were made in the new act. The personal insolvency is removed from the sole jurisdiction of a public officer, that is the former trustee in bankruptcy, to the open market through the introduction of a licensing regime designed to admit private practitioners. And by that now we have had, I think, 13 licensed trustees. They have gone through the training at university, at the law school, I should say, and were issued with licenses. So they are now professional trustees. Also of importance to, as I said before, is that you need not go to the court in many instances. Say, for example, if a debtor is insolvent and the business is not viable, no more viable, what the debtor may do is apply to the supervisor that for an assignment, that is for all his assets, to be assigned to the trustee for the distribution to debtors. And in so doing, he would become a bankrupt, yes, but he would not need to go to court. That has helped to remove, I should think, aspects of the stigma from bankruptcy, in that it is not a court proceeding where a person is virtually, say, found guilty of bankruptcy. It is something where he voluntarily assigns his property to a trustee for the distribution to creditors. That is very important. Let me go quickly now to how we think that the Office of the Supervisor of Insolvency, as it is set up, seeks to carry out its mandate. The Office of the Supervisor of Insolvency functions as a licensing authority for the insolvency practitioners. Secondly, it supervises the administration of insolvent estates and ensures that trustees are acting in compliance with the Insolvency Act. And it serves as a repository for information relating to insolvency administration. This is in a condensed form what the Office of the Supervisor of Insolvency seeks to do in making Jamaica a country where investors would want to come by having this.
Justice,
Yes.
Justice, have you seen recently that there has been an increase in the number of persons seeking insolvency protection?
Yes, not recently, I should say, but in comparison to the 5 years prior to the enactment of the Insolvency Act, we have seen where more companies have sought to use the Insolvency Act. If I may just say briefly, between 2015 and 2020, we have 29 different companies which utilized the regime. And that period, 5 years, that is 2011 to 2016, we only had 17 companies that went into liquidation. So we have seen an increase in that regard. But I must confess, though, that not many persons, not many, especially entrepreneurs, not many of them know the details of the Insolvency Act. Hence, we have started out on this sensitization program where we go to different places and we speak.
Advise people.
Yes, we advise people.
Okay. All right. Thank you, Justice. So if the audience who's going to have any questions, you can please send them in. But let me ask Hillary, what Justice just mentioned, the whole matter of people accessing, and you had mentioned about accessing early. Can people actually avoid legal issues by utilizing it early? Because I think that's important, right? For us to understand.
Yes, definitely. So, I mean, it does require them to have an understanding, as I would mention, of, you know, what are their assets looking like? What is their cash flow? What are the fundamentals of the business, so that they can also project. They have a sense of what's coming down the line, and therefore can start those discussions early with their creditors. Because it is going to be important to kind of assess, is it going to be likely that I am going to be able to put together an arrangement that my creditors will accept? Because if it is that your creditors are unwilling to accept the arrangement and you venture down this avenue, what will result is that you will end up in bankruptcy. If it is that your creditors are not on board, if your creditors do not have confidence in your ability, in the structure and arrangement that you will come up with your licensed trustee to help you, to bring you out of this crisis.
So tell the people what's the difference between the insolvency and the bankruptcy now.
So insolvency would be the state of, you know, your liabilities being greater than your assets, to put it, you know, in short. And bankruptcy is the formal proceeding where you have been declared
And you don't want to get to that.
And you don't want to get to that stage. But even if you do, there is an opportunity using the proposal mechanism to come out of bankruptcy. So even if you are bankrupt, you can use the proposal mechanism. And if you're able at that point to make that arrangement with your creditors, you can come out of bankruptcy.
Okay. So Howard, I mean, with what we see what's happening now, I mean, I'd written an article about 2 months ago. I projected the economy would fall maybe 10 to 15%. I think closer to 10%. What do you see? I mean, you're the former head of the private sector. You're a business person out there. You know, I mean, some significant issues out there, eh?
I see a tightening up of the market. I see that people are restricting their liquidity. It's not that there's not liquidity in the economy, but people are very, very cautious and being very, very cautious about the use of their liquidity. And I also see, and this is historical, we have a tendency in the business community to mistake cash flow for profit. Okay? Mm-hmm. And much of our businesses are distributive businesses, and cash flow you will be fooled into thinking that you have a lot of money because there is this stream of cash going through as your inventory exchanges itself. Now, what I am afraid of is that, as you have said, is that our economy is contracting. We have lost tourism. We have lost a substantial amount of mining. There's not that much going on with mining. We have lost much of our BPO businesses. And there is a contraction generally of buying, of the turnover, the velocity of money has slowed down. That is going to put a heavy burden on working capital for businesses, on cash flow for businesses. And when cash flow stops, that is when you find out that you have a working capital deficit. And by that time, it may be too late to turn it around. And that is why I'm saying, find the insolvency supervisor, go to your banker, and make sure that when you're going there, you carry proper records, because that's how they're going to help you.
But that's an issue, Justice. So, Justice, when someone approaches you and they don't have proper records, how do you deal with that issue?
Well, what you would do initially is to determine whether or not this person is insolvent. In fact, we can either look at the cash flow or the balance sheet test, whichever we choose. But once we are satisfied that the person is insolvent, in that he owes at least $300,000 and he cannot pay his debt, and that is easy. Cash flow can easily indicate that. Now, after he has filed the notice of proposal, the law gives him a kind of a respite from his creditors. And during that period now, he will have a trustee, and the trustee will assist him to put together all the documents that must be filed before a proposal can be considered.
Yeah, so I mean, the issue comes up now, Hillary, is that someone who already owes $300,000 is going to say, boy, I can't afford Hillary, you know, she's a big lawyer and I can't afford an insolvency person to come help me out. I mean, what did they do at that point?
So that actually is back to this officer supervisor, because there is a government trustee who, if it is that the assets cannot completely support, you know, being able to pay somebody, because ordinarily the trustees, the persons advising the trustees, those expenses of the process would be payable out of the assets. But if it is that the assets can't bear that expense, there is a possibility for the government trustee to be appointed to step in to assist.
Okay. So, Barnaby, we hear you're back now. Here, the technology was hit by the virus for a little while. So, Barnaby, in your experience in Cayman, what has it been like? Because we are here. I mean, Hillary was the one who introduced the new landscape a few years ago. But I understand you've had some experience there with it also.
Yeah, very much so. That you know, I wanted to try to give the panel a bit more of a sort of a global feel on the restructuring perspective, and really how a sort of a very well-trodden restructuring path is sort of approached through the Cayman Islands. Obviously, we've all been in lockdown for quite some time now, and the virus, I believe, is now sort of, you know, once it took hold, you know, businesses and economies, they really took a back seat. Whereas now the virus appears to have slowed a little bit. You know, the focus is back towards, you know, understanding the recovery.
Yeah, go ahead, Barnaby.
Can you hear me? Okay, yeah.
I hear you.
And sort of the businesses, I mean, restructuring is clearly a vital tool that needs to be considered when looking at viable businesses that want to come through the sort of the other side of this storm. The Cayman Islands have had a very long history of assisting businesses restructure, really stretching back to the times of sort of Enron and sort of notable banking institutions. Often the restructuring is done in partnership with other jurisdictions, more often than not in the United States, Asia, the United Kingdom. The Cayman Islands has got a regime and a court system that's really been set up to assist businesses to survive. Really, I mean, turning to our legislation, the Cayman Islands doesn't have the sort of the Chapter 11 or the US equivalent or the United Kingdom administration. But what it does do is it takes effectively what we call provisional liquidation and uses that as a way to assist businesses to restructure. And once you go into a provisional liquidation, really, I mean, there is a moratorium or a stay on claims by certain creditors. But as the panel, I think, has suggested, I mean, despite the fact that the courts in Cayman have come across sort of very innovative solutions to assist companies to restructure, the precondition of filing a winding up petition can certainly be difficult for directors and shareholders. They may not be familiar with the process, and there's certainly the taint of liquidation can impact on asset values, and also, just insolvency can certainly trigger cross defaults and things like that. So from a Cayman perspective, I mean, our legislation has needed to move with the times as well, and we're actually in the process of sort of revamping our legislation to sort of decouple it from liquidation and try to bring it more towards a sort of a restructuring officer domain. Obviously, if you can allow a business to restructure outside of a liquidation, the likelihood of that business restructuring is increased, jobs are preserved, creditors are going to receive a higher return. And really what a company needs at that time is time to assess, what its issues are, work with the relevant professionals, whether they be trustees or whether they be courts or otherwise. And Cayman, I think, is a very long way down this process. And we've actually had companies come to Cayman and migrate from, for example, the Marshall Islands to take advantage of our insolvency legislation. So, I mean, all in all, insolvency legislation coupled with sensible restructuring legislation, is certainly a good way forward. So I'll pass it back to the panel.
Okay, thank you, Barry.
So Howard, I was mentioning you're a past president of PSOJ, right? Very successful business person. What do you think about organizations like PSOJ helping their members to align themselves and prepare for this? Because this is coming, eh?
Well, there are opportunities. There are opportunities in a number of ways. One, the business associations, not just the PSOJ, the private sector organization of Jamaica, but the Jamaica Manufacturing and Exporters Association and Jamaica Chamber of Commerce. I really think that it is time, in addition to the assistance they have been giving to micro and small and medium-sized businesses in terms of getting financing, it is time to add a component to that. Now, you say, okay, you got the financing in your business, starting up in your business, not doing so well. Let's teach you to recognize the signs and to remediate. Right. So that's one area. Two, the banks themselves have an interest, a vested interest in keeping track and in assisting their clients. Because my concern is mostly the small and medium-sized businesses. The big businesses generally tend to know when they're in trouble, right? But my concern is that sector. And I really want to encourage the financial institutions and the business institutions to implement a program of awareness and sensitization, and to tell people as individuals that it suits you to keep track of your business and to understand that we are heading into dark, uncharted and never before seen waters. So maybe it's time for you to put off the purchase of that new car, right? And to look maybe at selling one of the vehicles and to put the money back into the business so that you can shore it up. The government also has a strong responsibility to hold the structured economy together and to encourage people to go to the supervisor of insolvency early. So I think we really need to open that chapter of sensitization, Dennis, and get the word out there.
So just following up on that then, for both Justice and Hillary, a participant has a question. How can we be sure that persons do not mismanage their businesses and use the route to avoid creditors?
So, I mean, the interesting thing in order to be able to assist with that process is that when you go through a proposal mechanism, for example, which is the rescue sort of measure that the legislation provides for, you're working with the trustee, you're working with a trained professional who's supposed to give you that kind of guidance and assistance. And the trustee remains a part of the process until the process is completely finished. So the proposal sets out the measures by which, between yourselves and the creditors, you've worked out how it is that we're going to pay, whether it is less cents in the dollar or we're going to allow greater time. The trustee is going to work through that process, work through the creditors, and remain involved in the process to get you through to the other side. And so that gives comfort to other people dealing with you. That that gives comfort to the creditors to know that there is still the licensed trustee in the process. To guide you through that process, to help you through, and to ensure that the payments get made when they're supposed to be made. Those funds are coming through.
So, Justice, You're here with us? Yeah, yeah. So how do you ensure that your office maintains the credibility that's needed to protect against this sort of perception?
Okay, may I just say something just before this? The Act provides for the counseling, financial counseling of debtors. And even in a proposal, the trustee or the creditors might order that the debtor, that he should undergo some financial counseling to identify why the business went bad, etc., etc. Now, you ask, how do I ensure? Could you just repeat, how do I ensure that?
Yeah, how do you ensure that your office maintains the credibility to prevent the perception of people that you're using it? Businesses are just using it to escape creditors.
Well, that is part of the whole sensitization program, you know. People, and we have in social media now, all around, educating people as to what the insolvency is all about. Because so many persons might well think that the Insolvency Act is to help the corrupt debtor. It is not so. The Insolvency Act is really to assist persons who have honestly tried but have come upon hard times. And the Insolvency Act now is aimed at helping them to restructure and to have a new beginning, so to speak. And the Insolvency Act provides for the creditors at the meeting to have control. The creditors can change the trustee if they want. The creditors can demand that certain things, sorry about that, be done. So the creditors have a controlling role to play at meetings of creditors.
Okay, that's very important, Justice, because so what it means is that the creditors are the ones who control everything. That's so right. It's not like you're giving up your money then.
That's right. And to add, if it is that, you know, the person is using it just as a means to go, if the process fails, he's back in bankruptcy.
Yeah, yeah.
So
it's within his interest to work with the creditors.
His interest to work with the creditors to try and get
So Howard, for yourself and Barnaby then, another question. We want to encourage entrepreneurship, but how can we change the stigma that businesses face in becoming insolvent? Yeah, you want to take that first? Yeah, and then Barnaby.
I think that it is only through public education that we can do that. And also, we have a society that suffers from a lot of cultural cognitive bias, okay? That we have preconceived notions about people, okay? That is a process, and that process has to be led by the business associations, by our government officials, by Justice Smith, and by us. So it is going to be a process over time. But immediately what is helping us is that many of our business people now are younger business people who don't suffer from those kinds of cultural prejudices. So I think that we can get there. And Barnaby may have some perspective from Cayman, because Cayman is a place where the volume of business is huge. So he may be able to help us with that.
So yeah, absolutely. I mean, you know, I'd certainly echo the panel's comments regarding education. I mean, education and understanding the system is clearly vital. Cayman has spent a long time sort of making sure that the global economies understand the Cayman restructuring regime. And I think having understood that regime, there's a lot of faith in that system. We have years of sort of case law as a result of all the cases that have come through. People really understand how that system's going to operate. And once they use the system, you know, the key aspect really is that once you have a predictable outcome to the process that you're using, people have a lot more faith in it. And that's why a lot of companies will relocate to Cayman. They'll use the restructuring regime because, you know, they have faith in the court system, they have faith in the legislation, and that all comes through years and years of education. And it sounds like you're taking the sort of the first step in Jamaica down that road. But that's clearly the first and most important step, I think.
Okay, thank you. We have another question, Justice, which you can help us with.
What's the 1, 2, 3 steps to filing, and what is the average time frame that it takes to go through this process?
Filing, let us say the proposal. Debtor, he would normally, he can go to a trustee directly, but he might come to us and discuss.
Would you advise him to go directly to a trustee or come to you first?
I would advise him to go to a trustee if he can. That's the thing, if he can afford a private trustee.
Okay.
Many of them say that they can't. But the private trustee, they are well prepared, they are professional persons, and they can give very good advice. And they have given good advice, we know for sure. But the person might not be able to afford the private trustee, at least in that initial stage. So he will come to us, discuss the problem with us, and if we are satisfied that he is insolvent or perhaps will be insolvent 12 months down the road, then we would advise him to file what we call a notice of intention. That notice of intention is normally filed by the trustee, though. So if the person is impecunious, we would send him to the government trustee who would assist him to file that notice. And as soon as the notice is filed, then there's a stay on all proceedings against him. And the law provides that within 30 days, of course, that can be extended, but within 30 days now, he must file his proposal. And even within those 30 days, he must file a cash flow statement, give notice to creditors, and so on. So you see, the time frame here depends on the creditor being able to file a proposal. The law gives him the maximum of 6 months, because 5 months through extension and the first 30 days. So it is not a matter of, say, how long will he take. It depends on the type of administration, the estate that he has. A very small estate, perhaps in no time at all, and a proposal will be filed. But we have seen cases where proposals go right to the 6 months before it is filed, because of the nature of the business in which the person was involved.
So where can people find trustees, Hillary?
Well, we have a list of them now. We have given them to persons who come, and they check them out, and they might come back to us to say they can't afford these trustees, any of the trustees. But we give them a list of these qualified professionals.
Okay. And these people are people you would have vetted and licensed and everything, right?
Yes, definitely. They would have been licensed, and they are fully trained to be licensed, and the character, all the checks would have been made.
So Hillary, here's a question I want to ask, because we tend to
Focus on the business people and the stigma surrounding them. But have any of your clients ever come to you and say, "Boy, listen, the impact on my family, and what's the impact on the people that they're associated with?"
Well, we tend to see more the concern relating to their businesses.
Yeah.
Personally, that's what we tend to see. But the impact on family and persons around are real concerns. There is, and again, this is primarily because even though there are changes in the legislation, hoping to drive the changes in the culture, that takes time. And so that question of what will people say, how will people view this if I have to go through this process, that's a real concern that persons have. But the movement that we've made away from the court for a lot of these processes to get them started, get them through, also allows for that process to therefore be shortened, for you to get out of the situation, or even if you're declared bankrupt, for you to get to the end of that stage and be an undischarged bankrupt, a discharged bankrupt, where at least that is behind you and less of a continuing concern, which is what has created much of that stigma in the past.
And again, Howard, I want to remind people that Apple was almost bankrupt. Walt Disney had filed bankruptcy, and many people who are doing very well today. So someone has a question: how important is it for this sort of legislation to exist to make a market attractive to investors?
I think it's fundamental to investors, that because investment is about risk management, and you struck a chord there a while ago when you spoke about the impact on the family. Yeah. Not every business I have been involved in has been successful. And I mean, we don't have time here this morning for me to tell you about the failures.
But the one though, the one successful one.
The important thing is that when you do hit the success one, it carries you past. So that again comes back to this idea of failure. If you fail, get up and try again. And it makes it harder for you to do that if people are around you feeling ashamed or being condemnatory. And it does impact your family. So that legislation like this, the Office of the Supervisor of Insolvency and the openness of the Office of Supervisor of Insolvency helps you to balance your risk assessment when you start a business, because there is no business, it makes no sense to start a business only being focused on success. You have to focus on the issue of what happens if I fail. And what is clear to me is that if I fail in my next business, Justice Smith is there to pick me up. So that, it's fundamental that we have these kinds of safety nets, these umbrellas for a rainy day. It's part of being a mature economy.
Barnaby, what about in the Cayman there? I mean, what would you say is the importance of this sort of legislation? Because Cayman has done very well in terms of attracting international investors, and this would have played a part of it, eh?
Yeah, very, very much so. I think that, having a simple and clear and reliable level of legislation, plus I think you've got the judiciary who really understand sort of cross-border restructuring and sort of international finance. And then obviously on top of that, we have what we call qualified insolvency practitioners, who are effectively, what I understand, your equivalents of the sort of the trustee who are sort of dealing with those sorts of issues. And those are effectively chartered accountants who are officers of the court, who will deal with creditors and debtors in a sort of an even-handed and, more often than not, predictable manner. So I think it again comes back to that sort of faith in the system, understanding how the system works, and, really looking at the predictable outcomes that a restructuring can give. And obviously, I suppose the key point to remember is, well, look, not all businesses succeed. Certain businesses will fail through this procedure. But at the end of the day, it gives them a chance in order to sort of move through and save what businesses can be saved.
So Hilary, Barnaby spoke about simple and clear, because the truth is that one of the problems with Jamaica is the bureaucracy and the legislation. It's just not a simple process in Jamaica.
So, I mean, that was definitely one of the tenets that was guiding that process in looking at the revision to the legislation. We were trying to make it as reader-friendly as possible. So, I mean, it is fairly clearly set out what are the steps that you need to take. How do you take each of those steps to guide you through that process to be able to find that measure of rescue opportunities that are available. And in the Jamaican context, one of the fears that we had in looking at our legislation was that we knew our courts were particularly bogged down. And I heard Cayman relies very heavily on their courts in their structure. But that was a concern that we had, that our courts are under some
that's right. I mean, we have a specific financial services division which simply deals with sort of corporate and sort of those sorts of insolvencies. So it's a very, very streamlined system that we have in Cayman. So largely sort of divorce or family or criminal judges
commercial division of our Supreme Court that is dedicated to commercial matters, and within that division, the insolvency division is there, and we have persons who deal with ours. But we also wanted to truncate that time as much as we could. So wherever there was no objection to various processes, there was an avenue to get through without having to go through.
So Howard, I mean, a question came in that I know. I mean, you have the memory.
Somebody remembered one of my failures.
But certainly, I mean, I don't think this would have passed without someone mentioning FinSac, the FinSac era. If this sort of thing existed at the time, do you think more companies would have survived and maybe would have escaped a lot of the debt we have today?
Most definitely. And let me say something about the FinSac era. I think we can learn from the mistakes we made there and the harshness with which we judged businesses that failed in that period of time. Yes, it was a tremendous cataclysm, but I think there was more suffering because of how we went about it. So I commend this particular piece of legislation. I commend the supervisor of insolvency and the work that you have done, Hillary, because it softens the blow and it makes it more efficient. Okay, we still haven't gotten rid of the trauma of FinSac. It is burnt into our psyche. And legislation like this and activities like this will help to bring a perspective that is more practical and real.
So Hillary hasn't gotten her national award for this yet, but it's coming soon.
If she needs a sponsor.
So, Justice, a question is on us now. Is there any Jamaican company or local example that went through the process that you can identify that is doing well right now?
Let me see. That is doing quite well. I am not too sure we can identify them. There might be companies that are doing quite well, but I don't know if I can identify any in particular. What I do know that there are at least I know of one company that was doing reasonably well until catastrophe struck and pushed that company into bankruptcy. Let me put it this way. What if I might use this to say what I'm about to say? That particular company, through no fault of its own, not any financial problem because of its transactions and so on, but marauding criminals attacked that company, shot and injured clients, consumers in that company, and one of the consumers in particular sued the company. And the person was severely injured, no doubt about that, and got damages, millions of dollars, and they claimed, let me just put it short, claimed over 300, I think, $1 million. The company, of course, couldn't afford that sort of a claim. The company sought to make a proposal. And that one creditor who had the vetoing rights, according to all the actors arranged in voting, that one creditor stood out. In spite of the fact, it was shown clearly, the trustee pointed out clearly to the creditor, that pushing the company into bankruptcy would put her in a worse position than if she accepted the proposal. But the person still wouldn't. And that company is now in the throes of bankruptcy. But to come back to the question you really asked, no, I don't know of any I could identify and say, yes, this one went through the crucible of bankruptcy and, well, not bankruptcy, proposal. Because as you know, a company cannot be discharged. Once it goes into bankruptcy, if it does not go back to proposal and succeed there, if it goes into liquidation, that's the end of the company.
All right, thank you. So we just have a few minutes. I'm going to ask for everyone to sum up. I'm going to start with you, Howard, and say that from a business perspective, though, many times people just need to have a look at what their situation is. They don't necessarily have to go to insolvency. So, your view, how do people approach this then? They don't just rush to insolvency first. They
No,
take a look at
I
certain
certainly
things.
feel that this is a structured opportunity to assess your business. Okay?
Yeah.
And Justice Smith spoke of something which, again, has struck a chord, in that we are a society that is not compassionate. We're a society that is not understanding. We're a society that is not reasonable. And without reference to the particular example he gave, we need to open our perspective to understand that circumstances alter cases. So that where I think this piece of legislation needs to be, as does not happen with much of our legislation is not put to practical good use.
Right.
It is on the books, and it only occurs when, some lawyer
Not farmer lawyers.
but I'm saying this is a practical piece of legislation that can be accessible and can operate in
Yes.
full in the business community. So that's something that we really need to get the word out,
Yeah,
and I
yeah.
congratulate DBJ and the participants here in doing that.
And DBJ has a very good program, the voucher
Right.
technical assistance program that
again,
can help people.
Sensitization
to
of the
structure.
business community. We're
Yeah.
not hearing these things as much as we should, and we're not listening out for these
Yeah.
things.
So Hillary, your 1 minute summation.
So I would ride on that as well. That it's about getting the word out, because there are opportunities in the legislation. There are opportunities to find ways to structure your arrangement. The legislation is wide open. It doesn't dictate what kind of proposal you need to put to your creditors. It doesn't dictate what the solution is, but it gives you an avenue to find that solution. And if additional financing is what you need, it also gives you that avenue to make your creditors more comfortable by being able to give them this additional priority that they can use to give you more credit, or even to make the trustees more comfortable by giving them that sort of priority as well, to say, if you come along with me and help me to get to the other side, we can together get to a better position.
And you would add that people should stay close to their practicing lawyers,
Stay
right?
close to
Not
their
to
lawyers.
the former lawyers.
Not that's perfect.
Barnaby, what's your 1 minute advice for us from Cayman? You've had a lot of experience there.
Absolutely. I mean, I suppose we're at the other end of this spectrum, and what we can say from a Cayman perspective is that restructuring legislation really does work. If you work at it, you work with the trustees, you can come up with a process that certainly is best for everyone, both the debtors and the creditors. And, it's really a case of education and having faith in that system and letting it work for all concerned.
Okay, thank you.
And Justice, from your point of view, with all those books behind you, have a lot of knowledge. How do people access you, and what's your summation on it?
But looks are deceiving. Let's just say the Insolvency Act is working. And what we want for people to know more about it. And again, for debtors not to wait until it is too late. They're too far in debt before they come to seek aid. Another thing we are seeking an amendment, or more than one amendment we are seeking. But this particular amendment is to give the creditors the right to initiate a proposal proceedings. Many jurisdictions have followed that, because sometimes the debtors are timid for one reason or the other. But a creditor who sees the warning sign we need that legislation, so the creditor may initiate the proposal proceedings. Another thing too we need is for the trustee, not the trustee, the supervisor, to be given the statutory power to intervene where a creditor has unreasonably refused to accept a proposal, and it must be clearly unreasonable. And of course, the trustees, the supervisor's intervention would be, of course, subject to the approval of the court. We think that those two bits of amendment are quite necessary to assist us in having this efficient insolvency regime that will attract visitors from all over the world.
Okay, thank you. So we've had a very interesting seminar today. We've had 4 legal minds, 1 former legal mind and a business person. And I'm a justice of the peace, so I don't know if that counts also. But thank you for joining us. And we look forward to the next DVJ seminar, which is number 6 of this very interesting series. Thank you.